Good morning or good afternoon or whenever time of day it is. I'm Joe Considine. I'm an attorney. I practice in Palm Beach County, although my practice takes me all over the state of Florida. But I've been practicing here since the early 1980s. My practice, for the most part, focuses on the area of mental health and substance use, both with regard to family law matters and more particularly the Marchman Act. So I want to thank Eddie Stevens and the Center for Child Counseling, and I want to just give kudos to both of them. The Center for Child Counseling just does such great work, and I know Eddie is so committed to the work that they do. They are helping our community get better and hopefully avoid some of the things that we're going to be talking about today because of the work that they're doing. So what we're going to talk about today is how can you help your client or her family member who struggles with addiction or alcoholism. We all have had clients who've come in who themselves either have a problem or one of their family members has a problem, and they may be coming in to see you as a family law attorney because for a divorce, because the person that they're with, their partner, has a terrible substance use disorder. So we're going to discuss that. We're going to discuss the scope of the problem that we have in this country with thousands and thousands of deaths, the opioid epidemic, the alcohol-related death epidemic. We're going to talk about addiction and substance use disorder. We're going to talk about the neuroscience and how the brain is affected and changed, altered by repeated use of substances and how it can cool off with recovery and treatment. We're going to talk about the hijacked brain. We're going to talk about how we can help our clients and their family members, and we're going to talk about involuntary commitment to treatment using the Marchman Act as an effective tool. And what the science has told us is that involuntary commitment to treatment is at least as effective, if not more so, than voluntary treatment. And I'm going to share my screen. And so we're going to start now with getting the substance impaired individual the help that they need. And we're going to be talking about the Florida Substance Abuse Impairment Act. So the scope of the problem, so we're talking about substance use disorder and co-occurring mental health disorders. We're going to, we know the press and the media have been reporting for the last several years about this. So some of this you may know, but here's the hard numbers as reported by the Center for Disease Control. We've had 70 deaths from drugs in 1 year in 2018, 82,000 alcohol-related deaths in 1 year in 2018. In 1 year, these are more deaths from substances than all of our wars that we've been in since Vietnam for the total of that. And that's just for 1 year of drug-related deaths or alcohol-related deaths. There's more deaths from alcohol and drugs in any year than from car accidents and gunshots and AIDS. So the scope of the problem is obviously extensive. SAMHSA, which is a good agency to get a lot of information from, tells us that there's 23 million Americans who have substance use disorders, which is defined as when there's a recurrent use of alcohol and or drugs, which causes significant, clinically significant impairment. 43 million Americans have some form of mental illness. So this is in this country, 23 million have a substance use disorder, 43 million have some form of mental illness, 8 million have both a substance use disorder and a co-occurring mental health disorder. 92 million Americans report binge drinking in 2018. 23 million adults report heavy alcohol usage, and these numbers are all from 2018. And about 14.5 million adults had significant alcohol use disorder, which we'll talk more about what that means, but less than 10% of that number receive treatment. So you can see that's 12 or 13 million Americans have a significant alcohol impairment and do not receive treatment. Among mental health issues, anxiety disorder is the most reported. Depressive disorder is next. In my practice, I'm seeing psychosis that's coming from, that's drug induced, especially among the young with cannabis. And look, lawyers are not exempt from all of this. As you probably know, there was a study done in 2016, a joint study by the American Bar Association and the Hazelton Betty Ford Foundation that found that our problem, that our risk is higher than that of doctors, higher than that of the well-educated general workforce population, that in terms of self-reporting, 28% of new attorneys from 0 to 10 years in practice reported problematic drinking at the rate of 28%, so about a third of new attorneys. The number drops down a little bit overall to about 20% of all attorneys scored at a level consistent with problematic drinking. That's only for the highly educated workforce. They only score at 12%, and doctors are at 15%. The study concluded that, attorneys, that we experience problematic drinking that's hazardous, harmful, or otherwise generally consistent with alcohol use disorder at a rate much higher than the general population. And the same is true for depression, anxiety, and stress. So you have to be on guard about that. And we have a great program here in the state of Florida, FLA, Florida Lawyers Assistance. My former partner and mentor, Jim Robinson, was instrumental in forming FLA. So now we have to ask ourselves, what is addiction? And we know a number of bodies have defined it as a primary chronic neurobiological disease characterized by behaviors that include one or more of the following: impaired control over drug use, compulsive use, continued use despite harm, and craving. And addiction is actually the word that is used in by the general population. The folks in the mental health field have, under DSM-5, have changed using the word addiction and now call it a substance use disorder. Some of that helps remove the stigma of using the words addiction and alcoholism. So when a person has a problem with alcohol that's a clinically significant impairment, we say that they have an alcohol use disorder. And as we talked about before, a substance use disorder occurs when there's a recurrent use of alcohol and or drugs, which causes clinically significant impairment. And this is from the DSM-5, which is the standard classification of mental disorders, which is used for clinical and research, policy, and reimbursement purposes. It's what the folks in the mental health field refer to when making their diagnoses. And what they do is they refer to it as, let me go back one. They've changed the terminology, like I had said, and they now refer to the use of a particular substance, such as alcohol, cocaine, a sedative, opiate, and then they refer to, and then combine that with the severity of the impairment. So for instance, you'll have an alcohol use disorder, which is either there's a mild impairment, a moderate impairment, or a severe impairment. The same holds true for cocaine, opiate, cannabis. There's a number of other drugs too. So that's how it's classified now using the DSM-5. Um, so what do substances do to the brain? That's what we want to now talk about. We talked about the scope of the problem. We've talked about concern for lawyers and the concern for our fellow Americans. So we know that substance use disorder is a chronic disease that changes the brain structure and the function of the brain. I am involved with the Max Planck Institute for Neuroscience here in Palm Beach County up in Jupiter. And the chief research scientist for neuron disorders and I were talking. I told her what I do in terms of helping families. And she said that, she said to me, substance use disorder is a severe neuronal disorder. And that was a few years ago that she had mentioned that to me. And boy, that really helped change my thinking around it from being something that, gosh, why can't this person just stop drinking or stop using drugs? With whatever shame or whatever emotional attachment that we as a society may hang on people who have these problems. This clearly, at least according to this neuroscientist, who's one of the top neuroscience researchers in the country, this clearly is a brain issue. It's a severe neuron disorder. So that helped me in my practice and in viewing clients and in viewing people who have a problem. And so let's talk a little bit about that. Let's talk about what happens to the brain. So we're going to talk about, what is called the pleasure signature. We all experience human pleasures, shopping, the first kiss, holding your lover's hand, a good meal, hearing a baby coo. These all register the same way in the brain. So that's where we're going to go now in terms of what happens to us. So excuse me. So these events trigger a release of the neurotransmitter dopamine into the nucleus accumbens and the ventral tegmental area. Both of these areas of the brain are midbrain, about 2 inches. The nucleus accumbens is about 2 inches behind the eyes. The VTA, the ventral tegmental area, is a little bit below that. But both of these areas of the brain are involved in motivation, reward, and addiction. And so when, the things that normally give us pleasure, like a nice meal, watching your team win a game, winning a case, right? You get a good ruling. These are things that trigger the release of dopamine into the nucleus accumbens and into the ventral tegmental area, and they provide motivation and reward. That's the way evolution has it set up, so that we act in this way on a continuous basis. The problem happens is when there's repeated exposures to substances or behavior, shopping and gambling and retail therapy, as they say. Gambling is a really difficult one. What happens is that the communication between the nucleus accumbens and or the VTA, the ventral tegmental area, and the prefrontal cortex. The prefrontal cortex is the part of the brain that is our executive decision maker. It is the one that says, there's a stop sign, stop the car. Hot stove, don't touch. You've worked long enough, go home and rest, or go play some golf or tennis or something. It's the executive decision-making part of the brain that helps us make good decisions for ourselves. So, and that's wired by neuropathways to the motivation and reward part of the brain that we talked about. And so, but when a person is using substances frequently, then that wiring gets changed, it gets altered so that it moves from liking the substance to actually having to require the substance, to needing the substance. And then what happens somewhat diabolically is that the prefrontal cortex becomes the servant of the dopamine receptors in the nucleus accumbens in the VTA. And so the way that manifests is that you'll hear the person who clearly has a problem minimizing it or being in denial about it. That's the prefrontal cortex operating to be able to protect the dopamine receptors in the nucleus accumbens so that it can continue to get what it wants. And this will happen so much in a person who actually has a significant impairment that the person forgoes eating, they don't sleep, they don't work. And what you see is, they stop parenting or they parent in a really lousy way. And that's because their brain has been hijacked. You probably remember Bill Moyer's, who was a really good media specialist, with Lyndon Johnson's media person. And he did a series in the 1990s on PBS called The Hijacked Brain about what happens to the person with the alcoholic or addict back then and how their brain is hijacked. And what we see on the next couple of slides are courtesy of Dr. John Dybin with the Hanley Center at Origins, who'll be presenting as well on this panel. We see the pathway, the brain reward pathways between the frontal cortex, the nucleus accumbens, and the ventral tegmental area. And then in this next slide, we'll see what happens to in the nucleus accumbens to the dopamine receptors when on the left-hand side, as I'm looking at this, where there's food, there's just a nominal number of dopamine receptors and dopamine present. And then on the right side, when you introduce cocaine into it, you can see what happens in terms of the frequency and the amount of dopamine and dopamine receptors. And so that's kind of the brain on substances, the hijacked brain. All right, let's move on now to what can we do? What can we do to help our clients? So, how do we recognize this issue, and how can we tell clients how to recognize it among their loved ones? Well, obviously, legal consequences, DUI, divorces, committing crimes, hospitalizations, emergency room visits, prior treatment episodes, loss of employment, and the obvious slurring speech, and poor hygiene, inattentiveness to life functions, relationship difficulties. You'll see those in your practice. Occasionally, the individual will say, and I ask my clients who come to see me, has your loved one ever said to you, especially in the morning, gosh, they're hungover, I need to stop this. My life is a mess. Every once in a while they'll say that thing. That's really good evidence that I use in presenting to a judge. Physical signs of use, empty alcohol bottles, drug paraphernalia, more red flags. These are additional red flags that are obvious. Functional decline, including isolation. That happens an awful lot. This is about that singer who her family wanted her to go to rehab, but she said no. So what do we do? What do we do, and how can we advise these folks who come to us? We know that treatment and recovery works. The science informs us that treatment works, and more treatment works better. The science is very clear about that. It allows the person with a substance use disorder to rest and recover and learn about their brain, learn about their behavior, learn about their triggers, But most important, it allows abstinence. It requires abstinence. Can't drink or use drugs when you're in treatment, although people try. But it allows abstinence so that the brain can cool down. So that process of the dopamine receptors always demanding more and more, and the wiring between the nucleus accumbens and the prefrontal calms down a little bit. And so then little by slowly, the process of creating new neuropathways occurs, neuropathways that will support long-term recovery, so that the simple things in life become valuable again. But you can't do that without abstinence, which is one of the critical parts of treatment. That and tending to the person's medical needs, making sure that they're resting, making sure that they're eating food, healthy nutritional food. So many people who especially older people, who have an alcohol use impairment, they drink, they don't eat. And so their body, gets sicker and sicker. And again, what do we do? Well, the evidence strongly suggests that the highest success rates for treatment and recovery come from a combination of long-term treatment with both internal and external motivating factors. And from the studies that have been done in something called the Principles of Drug Addiction Treatment, and this was done back in the early part of the century, the early 2000s, which created a research-based guide from the National Institute on Drug Abuse. They came up with these principles that remaining in treatment for an adequate period of time is critical for treatment effectiveness. And I'm going to tie in these principles into the Marchman Act, because the Marchman Act includes these principles. And the science indicates that the threshold of significant improvement is about 3 months in treatment. We can get a treatment order initially for up to 3 months. Let's see what's next. Substance use disordered individuals who have co-occurring mental disorders should have both disorders treated in an integrated way. The co-occurring mental health disorders that we showed earlier are anxiety and depression, or if you combine those, and bipolar. Sometimes you have borderline personality. But those need to be addressed at the same time that the substance use is being addressed, because one without the other is not going to, is a recipe for failure and a recipe for the person to use again. Let's see, another one of the principles is that recovery is a long-term process. It frequently requires multiple episodes of treatment. I sit on the board of directors at the Fern House for Men, along with Deputy Chief Mike Gauger of PBSO, and our executive director, Chuck Cordell, he's authorized me to say this, he needed to go to treatment 15 times before he finally got it. And now he's like 20 years clean and sober now. We also know that being involved in self-help support programs, both during and after treatment, are really necessary to maintain abstinence. So what happens when a client tells you that a family member or a loved one or a colleague or a neighbor has a substance use disorder, but they do not want to quit, no matter how much the family has begged and pled with the person, and threatened and cajoled, and if you love me, you'd go to treatment, and that person says, nope, not doing it. So what can you tell this client? Especially given some of you may be familiar with Al-Anon and some other recovery programs, and other well-intentioned individuals who strongly suggest, well, you got to kind of let the person hit their own bottom. And the problem that we have with that is that, in 2018, we had 70,000 deaths from drugs, and we had 82,000 alcohol-related deaths. So can we really say that what we ought to do is just let people hit their bottom before they get clean and sober, or do we need to do something else? And so what's suggested is to engage the client, have them engage the family member in a form of rational detachment. So what I recommend to families is that, that what you're seeing is a symptom of an active disease, like if it was cancer or kidney failure or diabetes is frequently used as an example. So you're seeing the symptoms of an active disease, and it's got nothing to do with you. And what you need to ask family member yourself is, what is my duty here? What is it that I should be doing? What active steps can I take to help my loved one? And I can tell you, as a parent who has put a child into treatment, it is not an easy thing to do, but it is doable, and it saves their life. I want to relate a story that I had a couple whose daughter was using heroin and was out on the street doing terrible things. And he was an attorney, and the wife had said, if we Marchman Act her, she may not be able to get into an Ivy League school, or she may never speak to us again. And this guy, this attorney, corporate lawyer, got his eyes welled up, and he said to me and to his wife, that may be true, but I want to know that if I'm standing at her gravesite because this disease has taken my daughter out and taken her life, I want to know that I've tried everything humanly possible to save my daughter's life. And that is as poignant a story as I've ever heard from any of my clients. And so that's a segue then into that we need to intervene legally is what the answer is, using involuntary commitment to treatment. I read David Brooks a couple of years ago. David Brooks is with the New York Times. He's an op-ed columnist. He's a moderate politically. He's not conservative, he's not liberal. But he wrote that the opioid epidemic of a couple of years ago was so severe that we needed a form of benign paternalism to combat it. And that, ladies and gentlemen, is what the Marchman Act does. It's a form of benign paternalism where the state has said, look, you're not making good decisions for yourself. So we as the state have a right to intervene and to help you because you're not helping yourself. So we need to intervene legally. And what's interesting is that, and I didn't know about this until I started doing research a number of years ago when I started this practice, is that there's plenty of science that tells us, that informs us that involuntary commitment to treatment is at least as effective, if not more so, than voluntary commitment to treatment. And that clearly is the science that says, we got to wait, that completely eliminates the argument that no, you should wait for people to hit a bottom. And so there's actual data, there's actual research that has survived scientific scrutiny that indicates that no, that involuntary commitment to treatment is at least as effective, if not more so. And there's studies here that are referenced there. And if you're interested in studies, email me, joe@joeconsidinelaw.com, and I'll be happy to supply you with these studies. So why does involuntary commitment to treatment work? We know, especially among licensed professionals, airline pilots, doctors, nurses, lawyers, they do better in treatment than the general population. Why is that? And a friend of mine in the treatment industry said there's skin in the game. They got skin in the game. The general population doesn't necessarily have skin in the game when they're in treatment on their own. And so what we see is that through the use of this program called the Human Intervention Motivation Study, the HIMSS program, which is set up with the FAA, impaired airline pilots do really well. They have the highest rate of success. It's like above 80%, 90%. which is an amazing statistic. But they have, if they hope to ever get back into a cockpit, they must do this. They must undergo screening and consistently be test negative for any substances, and it's long-term treatment and monitoring. And with this leverage that if you want to keep your job, you're gonna follow this. And we know that it takes at least a couple of years for the neuropathways for neural readjustment to occur, so that the neuropathways between the nucleus accumbens, the reward center, and the addiction center, and the prefrontal cortex takes time for that to happen. So how do we create skin in the game for the general population? People that don't have licenses, people that have not gone to years and years of school and worked hard to get a license and really have people who are licensed have a very strong motivation. Well, the Marchman Act creates skin in the game. The entry of a court order for assessment first, and then later a second order for treatment, the violation of which, the violation of this civil order, it's a civil order, subjects the individual to contempt and possibly incarceration, thereby creating skin in the game. A little bit of the history is that this is the Hal S. Marchman Alcohol and Other Drug Services Act of 1993. Which addresses the entire array of substance abuse impairment and co-occurring mental health issues. It's not the Baker Act. Hal S. Marchman was a minister up in Volusia County who tended to homeless people and to people who were addicts and alcoholics, and went to the legislature and said, there was the Myers Act back in the 80s and the 90s, early 90s. And Reverend Marchman said, we need something better. We need something that's more effective, both for alcohol and drugs. And hence they named this act after him. So now we're going to refer back to the principles of drug addiction treatment slides that we talked about a number of minutes ago. So the individual who's under a court order, for the time necessary for the brain to begin to heal, because we can get treatment orders for up to 90 days at a time. I've been able to keep people under some type of services order, treatment order, for 12 months. And so we know that the Marchman Act addresses each of the issues that we talked about under the principles of drug addiction. We know that treatment works, and more treatment works better. So why use the Marchman Act? So because we know that court-ordered treatment is effective. You see this in other instances, in criminal matters, in dependency matters. But most of the time people aren't involved in that. They're living their lives and they've got a substance use disorder. They're not involved in a criminal case, or they don't have a DUI. They're not in a family law matter. So we find that getting a court order, we call a nudge from the judge, is very effective. Legal pressure. This is the result of these studies. Legal pressure increases treatment attendance and improves retention. And individuals under legal pressure tend to have better outcomes than those without legal pressure. And again, there's some studies cited there. If you're interested, Joe at joeconsidineLaw.com, I'll send them to you. So one of the things that families ask me about all the time with the Marchman Act is, is this confidential? And yes, it is. The statute is very clear that this is a confidential process, that there can be no disclosure of any of the pleadings that in the case. In fact, if you know somebody who has had a Marchman Act, if you go to the clerk's website and type in that person's name, you will not see that there's been a mental health case filed against that person. There is some language in the statute that talks about good cause as a basis for being able to access treatment records. There's no case law that interprets this this provision. What I suggest is that it's just like the in the family law cases with child custody issues, time sharing issues. In that one case where there's where somebody was able to get treatment records of a mother who had tried to commit suicide, I think with the kids in the car or something, during the pendency of a custody litigation, the court found that that was good cause. In my estimation, it would be that level of egregious activity that would give rise to a finding of good cause. So I tell my family members to rest assured that it would be extremely difficult to breach the non-disclosure, and that this is a confidential process. This is an interesting part of the Marchman Act. You do not need to be a Florida resident. You don't need to have any time here. All you need to do is be present in the state for 10 minutes, and we can get a treatment order. And for that reason, interventionists and case managers and families out of state want to they encourage families to bring their loved ones into the state so that they can get a court order requiring them to be in treatment. So as we said before, the Marchman Act addresses both substance use disorder and co-occurring mental health disorder. I've been able to use it when there's really been primary psychiatric issues that don't rise to the level of a Baker Act. Usually these cases with psychiatric disorders, there's some level of self-medicating that's taking place. So they're smoking weed, or they're drinking, or they're using benzodiazepines. And that gives me the entree into the Marchman Act and substance abuse. So the procedure, now we're going to get into kind of the nuts and the bolts. The procedure is phase one is you file a petition for assessment and stabilization. Stabilization is also known as detox. You get an ex parte assessment order. You can, if it's a true emergency, most of these are, with pickup by law enforcement. If it's not an emergency, then the court schedules a hearing on an expedited basis. Once an assessment order is entered, then an assessment is done by a qualified professional. Qualified professional is a Chapter 490 or 491 licensed individual. Phase two is once the assessment is done, then we file a petition for involuntary services. This is the treatment part. So based upon the testimony of the assessing clinician and a fact witness, usually a family member, the court can enter an order for treatment for a period of time not to exceed 90 days initially. The legislative intent is pretty obvious. The statute defines what substance abuse is. It's the use of any substance if that substance is unlawful, or if it's detrimental to the user or others, but it's not unlawful. Substance abuse impairment is defined by the statute. It's a condition involving the use of alcohol or any psychoactive or mood-altering substance in a way to induce mental, emotional, or physical problems and cause socially dysfunctional behavior. So these are just kind of some side notes as we wind down here. We find more and more residential and outpatient treatment programs are including the Marchman Act in their business model because, number one, it gets people who need it into treatment. A lot of times families will call the Hanley Center at Origins or Life Skills or Futures or Beachway or any of these facilities and say that their loved one has a problem, but we can't. How do we help them? How do we get them into treatment? So more and more treatment centers now are recommending that that the Marchman Act is available. Number one. Number two, when somebody is initially voluntarily into treatment but then wants to leave, the Marchman Act can be employed to keep the person in treatment. So again, let's go back to phase one, the involuntary admissions. We're just going to kind of whittle down a little bit. What you've got to show is that a good faith reason to believe, and good faith is in there because every once in a while we get somebody who's going through a divorce or about to go through a divorce who wants to file a petition in the Marchman Act. That sometimes is good faith, but a lot of times that's not good faith. I had a case in Palm Beach involving two brothers whose their mother passed away, leaving an estate, and one of the brothers filed the Marchman Act against the other one because he wanted to get a leg up in the estate proceedings and to be named as the personal representative. We actually had a 2-day trial on that case. So a good faith reason to believe the person is substance abuse impaired or has a co-occurring mental health disorder. And because of that impairment or disorder, they've lost the power of self-control over substance abuse. That's number one. And either 2A or 2B, that they need substance abuse services, but by reason of their impairment, they lack the judgment to realize that, and they don't have the ability to make a rational decision about that, or that they're likely to suffer from neglect or refusal to care for himself, and that poses a real and present threat of harm to their well-being. So it's one, which is that there's a substance abuse impairment, and two, either A or B, because of the impairment, they need services, but they lack the insight, the judgment to get services for themselves, or that they're likely to suffer from neglect or refusal to care for themselves. Those are and that's the burden of proof is a mere preponderance on that. It gets harder as we move into the involuntary treatment, where clear and convincing evidence is required. And who can file a petition? Really, anyone who has, any single adult who has direct personal knowledge of the person's condition can file a petition for a Marchman Act. That's changed in the last couple of years. It used to be 3 unrelated parties or a family member. Yeah, this is always a concern here. Mental health counselors and therapists need to be a little bit wary because of the HIPAA issue and also because of the Florida Evidence Code. And 2 responses to that. One is that there's a HIPAA exception to non-disclosure, where disclosure is allowed or permitted when necessary to prevent or lessen serious harm to an individual. So that falls under there. So the testimony of the clinician who's done the assessment, in my opinion, I don't know if there's any cases on it yet, but my opinion, it's an exception to HIPAA. And then the Florida Evidence Code, the exception is there when there's a court order that requiring an assessment, and the clinician can testify under that exception. The court makes a determination either on an ex parte basis or based on a hearing. Excuse me. The order allows the person to be held for up to 5 days for assessment and stabilization. If a petition for involuntary services is filed during that 5-day period, after the assessment is done, but during that 5-day period, the facility can continue to hold the person until there's a hearing on the involuntary petition, the petition for involuntary services. Most assessment petitions result in an ex parte order without a hearing, especially if the petition is drafted carefully enough. And the court can order law enforcement to transport the person to the nearest appropriate licensed provider. Yeah, this is poor Fred. About the involuntary assessment, The assessment has to be reviewed by a physician and signed off. And it has to take place within 72 hours of either the order being issued or admission to treatment. It has to be telefaxed to the court without delay. This is important because we can't get a treatment hearing until this is done. If necessary, the provider can ask the court to extend the time for assessment. Providers making assessments have to define the process that they use to complete the assessment. These are under the regulations set forth by DCF. So these are, in any hearing under the Marchman Act, the individuals, if they cannot afford their own attorney, they're entitled to have an attorney appointed by the court to represent them. I've been called by a lawyer who's a legislator in Illinois who wanted to ask me about the Marchman Act. They were thinking about introducing legislation like that up there, and he said, "How is it that the ACLU hasn't sued you guys down there?" And I said, "Because there's a lot of due process considerations built into the statute, such as notice on all hearings, except on the emergency, the appointment of counsel, notice of all other hearings, the difficult burden of proof, clear and convincing." So anyway, and let's finish up this the assessment and stabilization part. So based upon the involuntary assessment, the person has to either be released, remain voluntarily, or retained if a petition for involuntary treatment has been initiated. So the second, phase 2, is the petition for involuntary treatment. And again, who can file it? The same people who filed the petition for involuntary assessment can file the petition for treatment. The contents of the petition are pretty much the same as they are for the contents of the petition for the assessment, except that you have to also indicate the findings and recommendations of the assessment, or that the assessment is forthcoming. The petitioner has the burden of proving by clear and convincing evidence the following, what we call Marchman Act criteria: that A, that the respondent is substance abuse impaired and has a history of lack of compliance with treatment for substance abuse. That part, the lack of compliance with treatment for substance abuse, I think it's not good policy, and hope to address that with the legislature in an upcoming session. But in any event, and B, because of the impairment, the respondent's unlikely to voluntarily participate in the recommended services, or is unable to determine for him or herself whether the services are necessary. So number one, A, by clear and convincing evidence, the respondent is substance abuse impaired and they have a history of lack of compliance with treatment. And because of the impairment, they're unlikely to voluntarily participate in the recommended services, or is unable to determine for him or herself whether the services are necessary. Now, one of the ways that we prove all of this, let's break this down. Substance abuse impairment, that's proven by factual allegations, the testimony of fact witnesses, the parents, the loved ones, the spouse, and oftentimes the individual who's being assessed will, in the assessment process, admit to the clinician that, yes, I've been drinking this amount, I've been using heroin. So a lot of times it's their own statements against interest that get introduced that prove up that the person is substance abuse impaired. The history of lack of compliance with treatment. Treatment can include therapy. So I will make sure to ask parents or loved ones, has your loved one been in therapy to talk about? If they haven't been to treatment, obviously many times these folks who come to us, they've been in treatment before. It hasn't worked that time, or it's been too short a period of time, 30 days. well, we know at a minimum 90 days are required. And then B, the respondent is unlikely to voluntarily participate. Well, if they've left what's called AMA, against medical advice, in the past, that's evidence of being unlikely to voluntarily participate. Or if while they've been in treatment, they've tried to abscond from treatment. The second criteria is that without services, this is similar to the assessment criteria, the respondent is likely to suffer from neglect or refusal to care for themselves. That neglect or refusal poses a real and present threat of substantial harm to their well-being, and that there's substantial likelihood that without services, the respondent will cause bodily harm to himself. At the hearing, the court's going to hear all relevant evidence. Witnesses obviously have to be prepared with firsthand knowledge, not hearsay. The client is to be present, so the respondent, the person with a substance use disorder, is going to be present in court unless it's injurious to that person. And then, as we said before, the burden is clear and convincing. And the court will then either dismiss the petition or order client to an involuntary treatment. Now, the secret in this is making sure the person is assessed by somebody who understands the Marchman Act and who knows what they're doing, because that carries the day most of the time. The clear and convincing evidence standard is met by having a well-credentialed assessing clinician who's taken the time and has reviewed the emergency petition for involuntary assessment, reviewed the allegations. If there's any attaching affidavits, they've reviewed that, and they go into that with the person. And what I do is I spend time training these clinicians on what the court's looking for. And when we get a good assessment, it's kind of a no-brainer as far as being able to meet this burden of proof. The court order that results from that will provide for involuntary treatment by a licensed provider for up to 90 days. The court doesn't get involved with what type of treatment or what level of care. There's various levels of care, from the most intense, which is a residential level of care, down to partial hospitalization, to intensive outpatient, to outpatient, to living in a sober living residence and going to support meetings. All of those things can be ordered by a court under a treatment order. So the court, obviously the court retains jurisdiction, because one of the things that happens is that when the Marchman Act criteria still exist, the petitioner can file a petition to renew involuntary treatment at least 10 days before the end of the 90-day period. And there's going to be a hearing scheduled in short order. And we've got prove up that the individual continues to meet the Marchman Act criteria. And then further petitions for additional 90-day periods can be filed if grounds for involuntary treatment persist. So, of the hundreds of cases that I have filed, probably 50% of them, there's going to be a petition for renewal. Maybe 10% or so of all of the cases filed result in a third petition being filed. And those are the cases typically where there's significant psychiatric issues that are going on too. So initially, the first 3 months, they're trying out different antipsychotic medicines. They're trying to just get the person's psychosis resolved enough so that they can start to address the substance use disorder. Just a quick note about mental health professionals, MHPs. They have not testified in court, and many times they're unafraid. They're afraid because they don't know this. And those of you who've, prepped psychologists and people who've done evaluations, know the importance of preparing your witness. I remind them that they're the only expert in the courtroom, and they're going to testify about what testimony is limited to whether or not the individual meets the Marchman Act criteria. And I, like any of us do, we prepare the person a couple of days in advance. So, a path forward, where do we go from here? We know that we have this enormous problem in this country with tens of millions of people who are, infected, afflicted with these terrible substance use disorders. And they interfere with so much of our, what I didn't include in here are the business losses, the productivity losses in the billions and billions of dollars because of substance use disorders. And so many of our fellow Americans have, in addition to the substance use disorder, the co-occurring mental health disorders, the bipolar, the anxiety, the depression, that also has to be addressed. The problem is it's clearly a significant neuron disorder. The brain becomes hijacked by these substances. It requires treatment. It requires a cooling off period so that the neural pathways between the pleasure centers, the motivation and reward centers of the brain, to the executive decision maker of the brain cool down and get a chance to have a neural adjustment period. And this happens in treatment. We can't wait for people to hit bottom anymore. We can't afford to do that. As David Brooks indicated, we need a benign form of paternalism. We've had, all these deaths in 2018. I don't know what the statistics are yet for 2019. These folks' prefrontal cortices are not working. We need to use, I tell my family members that you need to use your prefrontal cortex and ignore everything that the person is telling you about why they don't need this, because you're being lied to. Their hijacked brain is lying to you. And I tell the story of that lawyer who said that he wants to know if the disease takes his daughter out, that if he's standing at her gravesite, that he did everything humanly possible to save her life. And then finally, we know that by the science, and this helps parents a lot, this helps loved ones who have to pull the trigger on this, on filing this Marchman Act, in effect forcing their loved one into treatment, that involuntary treatment is at least as effective, if not more so, than voluntary treatment. The science is there, it's plain. And then lastly, we know that the Marchman Act is an effective tool to get people with substance use disorders the help that they need to recover. So again, here's my name and number, and if I can ever be of help to y'all, if you ever have any questions about this, I write extensively about it. Go to my website, Joe Considine Law. There's a lot of articles that I've written in there. I just again want to thank Eddie, and I want to congratulate him and the panel for the work that they've done in this, and hope that you all stay safe during this very difficult time that we're having, and wish you all the best.